Meta CEO Mark Zuckerberg taking the stand in a D.C. courtroom this afternoon, center stage in the biggest trial of that company's history. It's an antitrust case brought by the FTC that could force the tech giant to spin off Instagram and WhatsApp, acquisitions it made more than a decade ago that have since grown into social media powerhouses. The FTC is arguing that Meta built a social media monopoly through those purchases. Meta's chief legal officer has called this case weak. Let's bring in NYU Law professor Daniel Francis, who worked closely on this case and others when he was the deputy director at the FTC's Bureau of Competition. Daniel, welcome in. Describe to us the thrust of the government's case here.
Well, thanks so much for having me. And although these are complicated, fast-moving markets, the theory is really simple. It's that Facebook, in 2012 when it bought Instagram, and 2014 when it bought WhatsApp, was and remains a monopolist of personal social networking. And if there's one thing that antitrust law tells monopolists it can't do, is buy competitive threats. So the core theory of the complaint is that in order to eliminate what would otherwise be really beneficial competitive pressure, Facebook took these two threats off the market by buying them up, and that's what the FTC hopes to correct.
So the argument that Meta has made is that, among other arguments, they say the FTC's case ignores the social media reality here, which is that Facebook has this constellation, as Facebook says, of competitors, not just, Snapchat, et cetera, but also YouTube and also TikTok. And they say that they're not being anti-competitive because they have this massive amount of competition out there. What's your reaction when you hear that?
I think you're characterizing the argument perfectly, but here's what antitrust cares about. Can you get from those other services the same thing that you could get from Facebook and Instagram? And this complaint is focused on a really core type of service. That's personal social networking. Where do you go to show photos of your grandkids to your friends and family? It isn't going to be TikTok, it isn't going to be YouTube, and it certainly isn't going to be LinkedIn. So part of the FTC's core case is showing that there's this distinctive need for personal social networking, and Facebook and Instagram were the main two choices.
So Facebook has made that argument about competition for some time now as it relates to this case, but there's this new argument that they're deploying somewhat as of late, which is that the Trump administration is selectively applying the law in a way by, forcing Facebook and Meta, I should say, into court, but sidestepping enforcement of a new law that requires, for example, the sale of TikTok. I guess same jump of the question here. What's your argument when you hear that?
Antitrust, in some respects, is frustrating, in some respects, is beautiful, has a real purity to it. We recognize there's a bunch of other things we do to regulate different markets, including tech markets. Antitrust doesn't care about all that. It says if you've harmed consumers by eliminating or restricting competition, then a court's going to come in and impose a remedy. Doesn't matter whether for other reasons, whether it's national security, industrial policy, or anything else, the government might be intervening in different ways in the same market. Antitrust just cares about effects on competition and consumers. So that's the only story that's going to be in front of the court today.
Former deputy director at the FTC's Bureau of Competition, Daniel Francis. Let's stay in close touch on this because this case is not over. Daniel, thank you as always.